Good afternoon, everybody. I will call this meeting of the Senate Judiciary Committee to order. Will the secretary please take the roll?
Senator Flores.
Present.
Senator Orenshall. Senator Lang. Senator Nguyen. Senator Hansen. Senator Krasner. Senator Ellison. Chair Scheibel.
And I am here. Thank you so much. We have a work session today as well as 2 bill hearings. We will start with the work session. It's my intent to take the bills in order on the work session and then take the bills in order for hearing. So without further ado, let's open up the work session on SB 7. I'll invite Chief Jackson up to answer questions, and I'll turn it over to Mr. McDonald to go through the work session document first.
Thank you, Chair. This is Jared McDonald, Research Division, Legislative Council Bureau. Senate Bill 7 revises provisions related to pre-sentence investigations and reports, sponsored by this committee on behalf of the Division of Parole and Probation, and heard February 24th. The bill reorganizes certain requirements related to pre-sentence investigations and reports. And we do have one amendment proposed for this bill that was submitted by Washoe and Clark County Public Defender's Offices, and the amendment will allow the state and the defense the ability to waive a pre-sentence investigation report, or if they both stipulate to it, provide an order of, prohibit an order of contempt against the chief of parole and probation for failing to submit the report if they have not received the psychosexual evaluation, change the deadline from 14 to 7 days in NRS 176153, and delete subsection 8 of section 1 and subsection 4 of section 2. Thank you, Chair.
Thank you. And thank you for joining us again, Chief Jackson. I just want to confirm that you've had a chance to review this amendment. It is acceptable to DPS, and I'm going to assume it's acceptable to the DAs and PD since they are the ones submitting it.
Thank you, Chair Scheibel, members of the committee. Tamara Jackson, for the record, T-A-M-R-A-H, J-A-C-K-S-O-N, Department of Public Safety, Parole and Probation Chief. Yes, I have reviewed this, and we discussed this in multiple meetings yesterday, and I believe everyone is in agreement that this is an appropriate compromise and will be effective for everyone. Thank you.
Thank you. Any other questions from members of the committee? All right, not seeing any, I'll accept a motion to amend and do pass.
Second, Madam Chair.
Okay, we have a motion from, I think, Senator Lang and a second from Vice Chair Flores. Any discussion on the motion? Not seeing any. All in favor say aye. Aye. Any opposed, nay. The motion carries unanimously, and I will assign the floor statement to a volunteer named Senator Lang. Thank you. And that takes us to SB 60.
Bill 60 revises crimes committed against older or vulnerable persons. It was sponsored by this committee on behalf of the Nevada Silver-Haired Legislative Forum and heard March 11th. The bill expands the list of crimes against an older or vulnerable person that require the imposition of an additional criminal or civil penalty. The bill also increases the minimum term of imprisonment if a person convicted of residential burglary, invasion of home, or cause of the death or seriously bodily injury of a person 60 years of age or older during the commission of a crime. And we have one amendment proposed for this bill, and it starts on the next page, and it would delete all sections of the original bill and introduce new sections that increase the penalties for converting property and obtaining property under false pretenses, as listed in paragraphs A, B, and C of subsection 1 of NRS 205083, and a copy of that statute is provided on page 3 of the amendment. Thank you, Chair.
Thank you so much. I also want to thank the Attorney General's office. I'm sure that the members recall we heard 2 very similar bills, SB 50 and SB 60. The Attorney General's office did come up with this amendment and graciously agreed to share it with the Silver-Haired Legislative Forum to append to Senate Bill 60. Are there any questions? I don't see any questions, so I would accept a motion to amend and do pass. All right, we have a motion from Senator Lang. Second. We have a second from Senator Krasner. Any discussion on the motion? Yes, Senator Orenshall.
Thank you very much, Chair, and I appreciate all the hard work of the Attorney General, the Silver-Haired Legislative Forum. one of the legislators, I have to give a shout out to Fran Almaraz, president of the Silver Haired Forum, for all her work on this, who's my silver haired legislator. I'm trying to process the amendment. I still not sure I completely understand everything, so I'm just going to vote yes to move it out to committee and reserve my right.
Understood. And Senator Hansen?
I'm kind of in the same boat. The amendment got rid of a lot of stuff, especially the first section. I'm not sure. Is this considered a friendly amendment? Does anybody know? Okay, well, if not, I'm going to just do exactly what Senator Orenshaw just did. I'm going to vote yes, but we need to do a little more digging on some of that.
Understood.
Thank you, Madam Chair.
All right. I think that's all looks like that's all the discussion. All in favor, aye. Aye. Any opposed, nay. So the motion does pass unanimously to amend and do pass. I will assign the floor statement to a volunteer named Senator Krasner. And I also do want to remind the committee that I absolutely appreciate you guys letting me know when you are reserving your right. Of course, even if you don't say that you're reserving your right, you always have the right to change your vote on the floor, just in case anybody listening thinks that's not the case. So with that, we will move on to Senate Bill 62.
Senate Bill 62 revises provisions related to crimes. It was sponsored by the Attorney General and heard on Tuesday. We do have one amendment proposed for this bill, and that is attached to the work session document. As discussed in the hearing, the Attorney General proposes to amend the bill to delete sections 1 through 4 and section 6, authorize the payment of up to $1,000 for the remediation of property owned by a victim who is the subject of a hate crime, appropriate $60,000 over the 27 biennium to the Fund for the Compensation of Victims, appropriate $40,000 over the biennium to the Office of the Attorney General to provide support and resources to survivors of any crime prosecuted by the AG's office, and appropriate $1 million to the contingency account for victims of human trafficking. Thank you, Chair.
All right, any questions on SB 62? I don't see any. Oh, Senator Hansen.
Thanks, Madam Chair. Yeah, they got rid of some of the bad parts of the bill, admittedly, but the whole concept of setting up these funds, I mentioned it the other day in the hearing. I'm a little concerned about that. I think all funds that are collected from any criminal act especially should go, and we, honestly, as a legislative body, we should probably review that, but all that should go to the general fund and then let the legislature send it back out. I'm very uncomfortable with law enforcement agencies being able to collect funds from people that they prosecute or charge with crimes. And this would fall under that category. I mean, I'm obviously supportive of helping people who have been, abused in various ways. But the whole idea that of setting up these separate funds that are actually inside the Attorney General's office or, Sheriff's office or whatever, I'm just uncomfortable with. Anyway, I'm going to be a no on this one, but I think we're getting in the right direction on a lot of this. Thanks, Madam Chair.
Thank you. Senator Ellison.
Can I ask for to get higher chairs?
Both John and I need code books to sit on.
Madam Chair, and I said in the meeting the other day, I like the amendments, I really do, but I don't think it should go to the legislature. I think it should go to the governor's office. That way they can earmark that money strictly, whoever the governor is, to go to that. So I'm going to be a no, but I am going to reserve my rights. Thank you.
All right. Any other questions? Senator Krasner.
Thank you, Chair. I appreciate the Attorney General's office removing sections 1, 2, 3, 4, and 6, and I will be voting yes.
Thank you. Any other questions? All right, not seeing any further questions, I will take a motion to amend and do pass.
So moved.
All right, we have a motion from Senator Orenshaw. We have a second from Senator Lang. Any discussion on the motion? Not seeing any discussion. All in favor, aye. Aye. Any opposed, nay?
Nay.
Okay. For the record, Senators Hansen and Ellison are nays. The rest are yays. So the motion to amend and do pass carries. And I will assign this floor statement to a volunteer named Senator Wynn. Oh, actually, you know what? I will assign this one to Senator Pazina. That is what I will do, Senator Pazina. And with that, we will move on to Senate Bill 75.
Senate Bill 75 revises various provisions related to the duties of the Secretary of State. And this was sponsored by the Secretary of State and heard on February 20th. The bill authorizes Secretary of State to establish by regulation different amounts for certain fees and the penalties and fees for failing to pay such fees in a timely manner. In addition to other provisions, it also authorizes Secretary of State to accept certain records in a language other than English if sufficient resources are available to provide for a verified translation of the record. We do have one amendment that is proposed for this bill, and you can take a look on that. It's starting on the next page. This amendment would clarify that for the purposes of establishing different amounts and regulation for fees and penalties, the amount set in statute is a cap, and fees and penalties shall be no higher. It will remove all fees for dissolution of an entity. It adds a new subsection in NRS 76130 allowing for a customer to opt in to the automatic renewal of their state business license provided they have payment information on file. It adds a new subsection in NRS 77300 requiring the submission of an email address for certain filings, and to revise NRS 623210 to require the State Board of Architecture, Interior Design, and Residential Design to, in lieu of all examinations for a certificate of registration to practice architecture, to accept the credentials of any laureate of the Pritzker Architecture Prize. Thank you, Chair.
Any questions on SB 75 or the amendment? I'll start with Senator Ellison.
Thank you, Madam Chair. Of all the strong no's that I've had this year, it's this is the top of my list. I've got a real problem with quite a bit that was in the bill, so I'm going to be voting no. And I thank you, and I thank everybody that worked on it, but it just this has got a problem. Thank you.
Understood. Senator Hansen.
Thanks, Madam Chair. And I'm not sure which section I'm in here. Section 3, the penalties that the Secretary of State can apply, where do the penalties go afterwards? They go to the general fund, or do they stay with the Secretary of State's office?
I'm not sure if legal can answer.
I believe those would go to the state general fund. There's no provision specifically sending them to the office of the Secretary of State that I see right here, so that is where they go.
Okay, no, that's good. That's where all these should be going. But, no, this is another one that, that's a good thing. I just want to double check. But I'm very comfortable with the Secretary of State kind of almost independently being able to set penalties and fees for state business licenses. That's something that should be carefully regulated by us, I think. So I'm a no on this one.
Other questions on SB 75 or the amendment? All right, not seeing any. I will accept a motion to amend and do pass.
So moved.
All right, we have a motion from Senator Orenshaw.
Second.
We have a second from Vice Chair Flores. Any discussion on the motion? All right, all in favor say aye. Aye. Any opposed, nay?
Nay.
All right, the nays are Senators Ellison, Hansen, and Krasner. The rest are yays. And the motion to amend and do pass carries. I will assign the floor statement to a volunteer named Senator Orenshaw. And that takes us to SB 76.
Senate Bill 76 revises provisions related to securities. This was sponsored by the Secretary of State and heard on February 20th. The bill creates the fund for the compensation of victims of security fraud and requires the money in the fund to be used for the compensation of certain victims who restitution is owed. We do have one amendment proposed for this bill. It was discussed during the hearing. If you recall, the Secretary of State proposed to amend the bill to cap the fund at $500,000. Thank you, Chair.
Thank you, Mr. McDonald. Any questions on SB 76? Senator Hansen.
Sorry, I sound like a broken record. Okay, the money is coming from the state general fund and is being put into the compensation fund? Is that I following that correctly?
Not exactly. As I recall from the hearing, this is money that the Secretary of State would otherwise have to give to the general fund, but they're asking that they be able to retain up to $500,000 in this separate account to compensate victims of securities fraud.
Yeah, that order seems better. Thank you.
All right. Not seeing any further questions, I'll accept a motion to amend and do pass. We have a motion from Senator Krasner, a second from Senator Wynne. Any discussion on the motion? All right, all in favor, aye. Aye. Any opposed, nay. Okay, the motion carries unanimously to amend and do pass SB 76. I will assign the floor statement to Senator Wynne.
Next bill on work session is Senate Bill 213. This revises provisions related to the crime of unlawful dissemination of an intimate image. This was sponsored by Senators Stone, Krasner, Steinbeck, Buck, and others, and heard on March 18th. The bill provides that if a person who is 18 years of age or older commits the crime of unlawful dissemination of an intimate image when with the intent to harass, harm, or terrorize another person, the person distributes or causes to be distributed an intimate image. If the image is a representation, is created in a way that would lead a reasonable person to believe it is an actual depiction of the person, or the person did not give prior consent to the distribution of the image. And we do have two amendments proposed for this bill. The first was discussed during the hearing by Senator Stone, and it proposes to amend the bill to retain subsection 4 of section 2 and delete section 3. And then subsequent to the hearing, the Public Defender Office of Washoe County submitted the attached amendment, which revises the definition of intimate image and adds the word knowingly regarding the intent to distribute or cause to be distributed an intimate image in subsection 2B of section 2. Thank you, Chair.
Thank you. Any questions on SB 213? Not seeing any questions, I would accept a motion to amend and do pass.
So moved.
All right, we have a motion from Senator Lang, a second from Senator Hansen. Any discussion on the motion? Not seeing any, all in favor say aye. Aye. Any opposed, nay. All right, the motion carries unanimously to amend and do pass SB 213. I will assign the floor statement to Senator Stone, and I think we inadvertently skipped SB 125. So we will go to that one next.
Senate Bill 125 revises provisions related to services provided to victims of crime. This was sponsored by Senator Steinbeck and heard on February 27th. The bill authorizes a governmental entity to disclose certain confidential personal information to the statewide center to provide assistance to victims of crime for the limited purpose of providing support services, including, without limitation, referrals, advocacy services, and counseling. We have no amendments on this bill. Thank you, Chair.
Thank you. Any questions on SB 125? Okay, Senator Krasner.
I am known as an advocate for victims of crime. I bring many bills for victims of crime. I just want to make sure that we're not re-victimizing the victim with a bill like this that does not allow the victim to opt in if they want services. Not every victim of crime wants services. Some of them want to be left alone. And so I would feel much more comfortable if there was an opt-in section, if the victim gave their consent in writing that they want services before their confidential information is shared with other entities. So I'm going to have to vote no and reserve my right to change prior to floor. Thank you.
All right. I'm not sure if you want the sponsor to address your concerns on the record this afternoon, or if you want to, please, go ahead.
Jonathan Norman for the record, NORMAN, Nevada Coalition of Legal Service Providers. It does have a may in there, and it also references that all the information sharing would have to follow state, federal law. Every government agency, whether it's the police department, DA's office, has a policy for releasing information, and we would expect that that would continue to be followed. And I hope that answers the question. And Chair, if I could, on, there wasn't an amendment, but we did have a stakeholder that wanted to make sure our legislative intent was clear. If I could I clarify
Please.
that? Thank you so much. The intent of the provision in Section 1, subsection 4 is not to preclude another organization that provides services from entering into MOUs with Metro Police Department or other entities. Thank you so much.
Thank you. Senator Hansen, did you have a question or, okay.
Thanks, Madam. No, I just want to, the bill does have a may in it. Just want to make sure it was on the record, but they cleared it up. Thank you.
Thank you. All right, I don't see any other questions on SB 125, so I'll accept a motion to do pass. Oh, all right, I'll take the motion from Senator Lang. I'll take the second from Senator Ellison. Any discussion on the motion? All in favor say aye. Aye. Any opposed, nay? Okay. The sole nay is from Senator Krasner. The motion carries to do pass SB 125, and I will assign the floor statement to Senator Steinbeck. And that takes us to SB 275.
Senate Bill 275 revises provisions related to domestic relations. This was sponsored by Senator Cannizzaro and heard on April 4th. It prohibits a court from issuing an order requiring a child to receive reunification treatment under certain circumstances, and prohibits a court from removing a child from or restricting contact between a child and a parent or litigant for the sole purpose of improving a deficient relationship. There are no amendments on this bill. Thank you, Chair.
Any questions on SB 275? All right, I would accept a motion to do pass.
Second.
All right, we have a motion from Senator Nguyen. We have a second from Senator Hansen. Any discussion on the motion? Not seeing any. All in favor say aye. Aye. Any opposed, nay. Okay, the motion carries unanimously to do pass Senate Bill 275. I will assign the floor statement to Majority Leader Cannizzaro. And that takes us to SB 347.
Senate Bill 347 revises provisions related to mental health crisis holds. This was sponsored by Senator Scheibel and Cannizzaro and others and heard on April 2nd. The bill authorizes an officer who places a person on a mental health crisis hold to immediately confiscate a firearm owned or possessed by the person, requires the officer at the time that the firearm is confiscated to provide the person with a receipt which describes the firearm and a notice which sets forth the procedures governing the return of the firearm. There are no amendments proposed for this measure. Thank you, Chair.
Thank you. And before I call for any questions, I would just like to let the committee know it is still my intent to produce a floor amendment on this bill. I've been working with the stakeholders to ensure we get the language right on this. And so I'm happy to answer any questions. But I don't see any questions. So I would accept a motion to do pass. All right, we have a motion from Senator Lang, a second from Senator Nguyen. Any discussion on the motion? Senator Hansen.
Thanks, Madam Chair. Yeah, this is a Second Amendment issue, and so we're a little uncomfortable with some aspects of the bill. We feel it's kind of unfair that a guy, assuming a male, whoever has the weapon taken away from him, but then without any judicial process, but then to get it back, he has to go through a judicial process. So it's a classic red flag law. So I shouldn't say we. I am a no on this one. Thank you.
Senator Ellison.
Thank you, Madam Chair. Yeah, I was hoping in the bill that they'd amend it that says that the court or the sheriff's department could remove and give back the weapon if there's no problems, to either the spouse or whatever, long as it's locked up and prepared. But I was hoping that was gonna come into this, so I'm gonna be a no. I'm gonna reserve my rights. But I'm hoping that change maybe will be made over at the the assembly, because I think that'll clear up a lot of that stuff that's out there. Thank you.
Thank you. Any further questions? All right. Or sorry, any further discussion? No further discussion. All in favor say aye. Aye. Any opposed, nay? Nay. All right, the nays are Senators Ellison, Hanson, and Krasner. The motion to do pass carries, and I will assign the floor statement to myself. That takes us to SB 432.
Final bill on your work session is SB 432. It revises provisions related to privacy and was sponsored by the Senate Committee on Judiciary. It establishes that family law proceedings are presumptively open unless an exception applies, and authorizes a court to exercise its discretion and close any such proceeding if the court determines that the closure is necessary to serve a compelling interest. The bill also makes an unlawful act punishable as a Cat C felony for willfully and intentionally posting or displaying any public manner certain personal information of another person without the consent of the person. And we do have one amendment proposed on this measure. Chair Scheibel proposes to amend the bill to change the penalty from a Category C felony to a Category D felony. Thank you, Chair.
Thank you. Any questions on SB 432? All right, not seeing any.
I would just like everybody else, Madam Chair, I just wanted to let folk know that I will be voting for it to move out. A lot of folk have been reaching out with many concerns, and I may switch my vote on the floor. Thank you.
Hopefully this works. I would like to also reserve my right. I have some questions that came in late. I know that's not on the sponsor of the bill and the presenters, but I would like to reserve as well.
Senator Orangel?
And just a ditto, same thing. I got contacted late with some concerns, and I vote to move it out of committee, but reserve my right, Chair.
And as the presenter of the bill, and of course it's sponsored by the committee, and as the chair of the committee, I think it is my responsibility to follow up on this bill. I'll also be meeting with stakeholders and, working with members of the committee to try to address concerns that remain with the bill. So, Senator Ellison.
Thank you, Madam Chair. I want you to know that I was not going to reserve my rights, and I was not going to vote no. Thank you.
Okay. Well, thank you. That being the case, I would accept a motion to amend and do pass. All right, I'll accept the motion from Senator Nguyen, the second from Senator Orenshaw. Any discussion on the motion? Not seeing any. All in favor say aye.
Aye.
Aye. And any opposed, nay? All right, the measure passes unanimously to amend and do pass. I will assign the floor statement to myself, and that brings us to the conclusion of our work session. And thank you all for your hard work today and always on our committee, but we're not done yet. We still have 2 bill presentations. Let's see, of course, I have one of the sponsors on the committee. So I will start with you, Senator Ellison, and SB 202. For the members of the committee, you should have a copy of an amendment in front of you as well, and it is posted on Nellis. Please go ahead whenever you're ready, Senator Ellison.
Getting warmed up for her. Thank you, Madam Chair. I'm here today to present Senate Bill 202. It's a provision related to house breaking and unlawful occupancy. Before I start, for the record, I'm John Ellison, Senate District 19, which is almost half the state. So I've got a very large district, and I have a lot of constituents that's running problems with break-ins, takeovers, here in Nevada alone, too. I have Senator Stone, District 20, that he amended his bill into me, thanks to Madam Chair, and we worked on it. But his house, one of his properties, were also broke into by squatters, did a lot of damage, and he ended up paying them to get them out of there. But what this law will do, I hope, will address them kind of issues where you don't have to pay somebody to get out of a vacant house or a house that's occupied by, and these were occupied by seniors that I think, I don't know if they were gone or if they let them in, but I know that the problem now has got to the point where it's extended beyond these break-ins and the damage that's being done and the stuff that's stolen out of these houses and hawked while these people are in possession. Good afternoon, Ms. Scheibel, committee members. For the record, I am John Ellison, represent Senate 19 in eastern Nevada, running this way, Elko County down to Clark. Background, I am sure that you know that the crime break-ins into the vacant dwelling with the intent to take up residence, to provide residence to another person without permission from the owner. It is also considered unlawful occupancy for someone to take residence in a vacant dwelling by someone who knows, has reason to believe is done without the permission of the owner and at the dwelling. Senate Bill 202 addresses the situation where the individual presents to use a false or forged rental agreement. Now we know also not only doing rental agreements to show that they rented the apartment, they're also getting numbers off of the meters, and with this rental agreement going in and actually moving the power over to show they do have position, they have the rights to be into this dwelling. So they're going beyond one area to the other. The key element to the intent to establish residence either for themselves or another person. This bill is designed to prevent unauthorized occupancy for properties, particularly those that are empty or temporary uninhabited. Section 1 of this bill revised provision related to the housebreaking to include use of false rental agreements to gain access with the intent to live there and let someone else do so. Section 2 of 1 revised revision related to an unlawful occupancy to instance for when a person lives in a vacant, unoccupied dwelling without the owner's permission, knowing or have reasons to believe they are not allowed to be there. It is also applied that if they use a false or forged rental agreement to justify their presence. The proposed amendment, these should be proposed exceptional amendments by analysis to exceptional agreement proposed to amend all section in section 236 to Senate Bill 202, including section 1, provide definition of the term squatter and tenants for the certain proposed related to the summary proceeding to the obtaining possession of real property, a recreational vehicle or a mobile home, and classified as a squatter is not a tenant of such proposed places. Section 2 reduces the period for which an unlawful to unauthorized occupant who has been locked out of the dwelling has a right to contest the matter by filing a variance complaint seeking remedy, and the owner of the dwelling is required to store a personal property of the unlawful authorized occupant. And I've seen that quite a bit on moving people out of, evictions or whatever. You'd have to move their stuff into a rental place and then lock them up and keep them until the courts take the second action. Section 3 verifies the process in which an unlawful occupant occupies who has been locked out must seek a return to his personal property, in which we do. Section 4 to expand the criminal or unlawful occupants to make an unlawful to take up residence in a dwelling regardless of whether it is prohibited or unprohibited or vacant. If the person knows it, or has reason to believe that such residence is without permission, the owner of the dwelling is authorized to present to the owner. The conclusion also Ms. Scribel and committee members, I urge you to support this bill. But what the thing is this, after the second offense, according to the first bill, becomes that they do this, the second offense apparently becomes a D felony. And I don't know what else you can do because it's expanding wider and wider as we talk. California, they said that they have to get somebody in to stay in some of these houses and pay them to stay there for weeks at a time at their own vacation because the squatters are moving in. And then the other thing we just found out yesterday is if you were, you see these signs that we'll buy your house, no matter how bad a shape it is, well, they're calling in on them, and next thing you know, they have possession of that house. So they're selling it and leasing it and renting it to these people, and they get a contract, but they never hit it. So it's gone from point A to point B overnight. And in Florida just passed the same laws. It's out of control, that they've got to do something to control these. And the only thing we could think of, Madam Chair, was try to put this into law here in Nevada, because it's in Nevada, it's in the rural areas, it's in the cities. I don't know how many's been in Washoe or how many's been in Vegas, but quite a few. So I'm hoping to make it as easy as possible to present this to show you how bad the situation is, Madam Chair.
Right, thank you. Are you open to questions? Do we have questions from members of the committee? Starting with Vice Chair Flores.
Thank you for the presentation, Senator. And I know back in 2015, I had an opportunity to work along with a bunch of stakeholders on the unlawful occupancy. I know squatters was a big problem. For the most part, some of it was addressed then, but I'm just trying to understand specifically what we're doing with this language. So presently, today, if there is an unlawful occupancy, whether the home is vacant or not, somebody goes into the property and you present a fake or forged document, isn't that already unlawful now? I'm just trying to understand what this language is adding, because isn't that already unlawful?
Yes, sir, but what they're doing is they're moving into these houses, and what they're doing is they're actually, if they can find it unoccupied or if they know the people are out of town, they're automatically moving in. They're making fake documents. They change every lock in the house. They board up every window, and then late in the middle of the night, they'll remove a lot of the possessions in there. But the one that they just found, the guy was hiding in the attic. When the police when they finally got possession, the police and the judge give them authorization to go into the house. So it is part in the law, but the problem is it's not qualified that these guys can be charged on a felony after the second time that they do this. Because the first time, they're just letting them go. Or the biggest thing is that right now, they're making you pay them to leave, to where you don't have to try to go through all these courts. In Florida, it was almost impossible to get them out of a house. The courts have set it back for months at a time. So what was good about it is they finally got this into law that says if you're in a house and you don't have the authorization to be there, if it's a trailer house, a house or a motor home or whatever it is, you can be held accountable and you can be arrested and removed. Right now, they just tell you to move and then take it to court. And that's the problem we're having. We need to give the police authorization to remove them out if we can prove that these documents are fake that they got.
Understood. All right. Thank you,
But
Senator.
I remember the bill you had, and we had one prior to that, and it was in your committee that we tried to work it out. But this had just made it simple. We're just trying to follow other states right now.
And maybe I can ask law enforcement when they come up to see how this is going to help them, because my understanding is to present a forged or fraudulent document is already unlawful. It's already unlawful for somebody to be a squatter. So I'm just trying to understand how and I'm all for helping law enforcement in whatever way we have to get rid of some of these folks, because obviously it's a problem. And when I was running for office the very first time, it's one of the things that they told me when I was walking the district that we had issues. I know that person there doesn't live in that home. I know that person there doesn't live in that home. So I want to help. I'm just,
But one of the things, if I may, Madam Chair, is to Mr. Perez, one of the things that's happening, you have to prove their documents are not correct. That's the big thing is, so not only do the police take the reports, then the owner's got to go get documents. They own it either through title companies or whatever, then they have to go to court. So you might be months trying to get somebody out of there whenever you can get a trial date. And that's some of the problems we're having. We need to move this up to get them out of there to where they don't steal everything that's left in the house or destroy the house.
thank you.
I'll go next to Senator Hansen. Oh, okay. Then I will go to Senator Krasner.
Thank you, Chair Scheibel. Thank you, Senator Ellison, for presenting this bill. And I appreciate the changes to the bill and the conceptual amendment that you provided. Section 1, which provides definitions for the terms squatter and tenant for certain purposes relating to summary proceedings. And then Section 2 to reduce the period for which an unlawful or unauthorized occupant who has been locked out of a dwelling has the right to contest the matter by filing a verified complaint seeking reentry. And then Section 3, of course, to clarify the process by which unlawful or unauthorized occupants who have been locked out may seek the return of their personal property. So thank you.
And I think our chair, because she could see the good in both bills and put them together, and that was a major deal because I would have never thought to went to there. So I thank you, Chairman.
All right, I think Senator Nguyen had a question?
I think I'm okay, actually. Thank you.
Okay, Senator Orenshaw.
Thank you, Chair, and thank you, Senator Ellison, for bringing the bill. You know, for a long time, I've known this is a big problem down in southern Nevada. I didn't know it was a problem in some of the less populous counties. Is this a problem in some of the areas you represent that are less populous, that aren't the urban thing? Because I certainly knew it was a problem in the urban area, but I didn't realize it was a problem in rural Nevada.
Out in the rurals, out farther out, you know, the people might have 1 acre, 2 acres, 5 acres, whatever. You'll seen it pop up. But we had one right down the middle of town. They had a heck of a time to get them out. Finally, the judge had enough time to take it and look at it and remove them out. But they were gone on an overseas or whatever vacation, whatever it was. And they were gone for 2 to 3 weeks. When they got home, there must have been about 8 people living in that house. And the destruction and damage was awful. But there's one right down the street from property that I own that they took over that, and I didn't know it until they finally got them out of there, so.
Thank you very much for bringing the bill. Thank you, Senator Ellison. Thank you, Chair.
All right, I think you inspired Senator Nguyen. Please, go ahead.
Yes, I do have a question. Sorry, I was trying to get my bill straight because I was looking at the amendment to amend sections of Senate Bill 236 into Senate Bill 202. And so I think specifically when we're looking at section 2 of your amendment, so I'm looking at that amendment, conceptual amendment document, and it talks about reducing the period of time for which an unlawful or unauthorized occupant who has been locked out of a dwelling has the right to contest the matter by filing a verified complaint. It seems like you're trying to reduce that from the 21 days to the 5 calendar days. And I'm wondering how you came up with that particular number. It seems to be moving,
Yeah,
I mean, our court systems, I would like to believe that they move efficiently, quickly, and easily for people going through this process. But in some of those circumstances, can you tell me what the thinking was in that amended language?
yeah, I think LCB put that language in, I'm not sure. I'd have to ask Mr. Stone, because that was his amendment, but it was, some of the problem we have is we're trying to get them out of there as fast as we can. And once we prove that the ownership is owned by the occupancy, you know, the owner, the actual owner of the house, or the renter, or even have that with renters right now. They'd be gone, next thing you know, the renters are their house. But the thing of it is getting into court sometimes in justice court, you know, you might be tied up for couple weeks, because, you know, they have 2 judges, and they're usually pretty busy. And even if you try to get into district court, you'd even be 10 times longer, and then you'd have to go in with a lawyer. So at least at the justice court, you can go in and say, here's my documents that prove that I own possession of this house. Here's the deed, here's whatever. But these people are getting so good at it. They're faking deeds, they're faking rental agreements, they're faking power bills, gas bills, everything they can do. So they're getting really, really good at it. That's why we got to get something into law. I'm not the smartest light bulb in the world, but one that cares about the people and that's losing their homes. What's bad is the destruction and the stuff that's stole out of these houses. These people walking in, there's nothing left, nothing. Even the pots and pans.
Other questions from members of the committee? I actually do have a couple of questions. I want to make sure that I'm understanding correctly. Part of the purpose here is that, if I am a bad actor and I want to make a buck, right? The problem you're trying to address is people saying, okay, here's this abandoned house or this vacant home. I am going to tell you, John, hey, you can rent my house even though I don't know. It's like the old Brooklyn Bridge scam, right? Yeah. I'm going to sell you a bridge. I'm going to rent you a house, and here's the deed, and you're going to sign it. Or here's the lease agreement. You're going to sign it, move in, and I'm going to take your money. And then you're going to be on the hook for being possibly convicted of unlawful occupancy. Is that?
But what they do is once they prove that they rented it from somebody, then usually you can work at them people because they got scammed also.
Right.
And that's been a good case. But as far as the rental homes, you have no idea how many there is. It's unbelievable. If they find an empty house or a house that's for rent, they'll go rent it. They'll rent it to people and meet them over there. But what they're doing is they're getting into the house and changing all the locks where they have possession of that house.
And so is the idea here to go after the person who ultimately moves into the house or the person who changed the locks and accepted the money from the person who ultimately moves
They're
into the
usually
house?
gone before the police finally get into the nuts and bolts of it. So not only did the owner of the home get scammed, but the people that rented the house got scammed. And then usually most renters will say, well, I can work with you, I can try to help you, but this is a case where you got scammed as bad as we did. But you got to watch signs out. If you got a sign out in your yard in some place that says for rent and a phone number on it, look out. Because they'll change that sign with their number on it. They'll rent the house, give them a fake contract, they're gone.
Okay. And so then I guess the party we're trying to protect is the rightful homeowner, because I think I'm understanding you saying that the owners of the home don't even know that this is going on.
Right.
Okay. And so if we were to pass SB 202 with the amendments, then would that allow us to hold the person responsible who offered the fake lease? I understand that they're often gone by the time. Actually, let me ask this. How is it normally discovered that this scam has occurred?
Usually the homeowners or the next door neighbors will call and say, oh, you thank God you rented your house or whatever. They rented the house, but there's 20 people in there, and the owners will go over and check and find out they rented the property, and they might have not been able to rent because there's a bunch of them, and that's how it gets back. But the problem is, unless you can find the culprit that rented the house, that's the problem. These guys are really, really good.
So, okay, so it sounds like normally we're going to be missing the person who offered this forged lease. You're going to have the person living in the house. You're going to have the owner of the house to help put the pieces together and figure out what happened. But what happens in the case where the homeowner has died?
Yeah, then you got a problem. Because I tell you what, they're so good, they've even changed titles.
They changed titles?
They fake title. They'll go to that house and find any documents they can find, whatever they can. They'll go to a title company. Have you seen these big ads on the papers now? It says, please take this insurance out to protect your titles being stolen. And that's happening. I don't know how much that is, but I know that the renting houses that they don't own, is a big deal. And it's become a big scam. But I don't know how you're gonna catch them that it took off. I have no idea
Okay.
unless somebody seen them and known them or got license plates or whatever. But the problem is the poor people that owns it. And they're even moving old people out of homes and moving them out, saying, hey, your rent's been canceled, at least you have to move. I own the house, or I rent the house, or whatever. It's got to a point where it's a scam. It's a big scam.
Yeah.
And I'm hoping this little thing might get it started, and I'm hoping to God that somebody up here or one of the other committees will take it and expand from it and put some good teeth in. I just got a call from the district attorney. I was gonna talk to him about what we could do, but anything we could do. We just want to get the foot in the door to try to help those that need help. But it's become a multi-million-dollar business for these guys. And it's everywhere.
Okay. Well, I appreciate you answering my question. And unless there are any other questions? All right, I don't see any further questions. Thank you so much, Senator. I will now invite anybody wishing to give support testimony on SB 202 in person to the front table here in Carson City or in Las Vegas. Come on forward and please go ahead when you're ready.
Good afternoon, Chair Scheibel, members of the committee. For the record, my name is Nick Schneider, Director of Government Affairs for the Vegas Chamber. Wanted to thank the bill sponsor for bringing this bill forward. We appreciate the expansion of unlawful ownership and hope this gets property back into the hands of the rightful property owners. Thank you so much.
All right, I don't see anybody else coming forward to give support testimony in person, so we will go to the phones, please, for support testimony on SB 202.
Thank you, Chair. The public line is open and working. There are no callers at this time.
Okay, then we will take testimony in opposition to SB 202. Anybody wishing to testify in opposition is invited to the front now here in Carson City or down south in Las Vegas.
Good afternoon, Chair, members of the committee. I hate opposing such a well-intentioned bill. Like, nobody likes squatters and nobody likes, it's generally the people on the margins that get tricked by the people, like they meet on Facebook Marketplace, they get a fake lease. Nobody likes those people that are tricking them either. I will say to the Committee on Lawful.
Sir, I think you forgot to give us your name.
I apologize, Senator Scheibel. John Pirro for the record from the Clark County Public Defender's Office. Very sorry for that. Out of practice. You as well. Unlawful occupancy is already a gross misdemeanor. As Senator Flores said, I think this body did a lot of good work on that. I was wondering if maybe some of the definitions, and this may be a question better posed to Mr. Wilkinson, like the definitions of tenant and squatter in these bills would affect any other definitions. And then one of the main concerns that I had with the bill was the reduction from the 21 calendar days to 5 calendar days. Obviously, I want any homeowner to be able to remove a squatter from the property as fast as possible, but I also know that there are some landlords that are not the best actors and that would use this process to get a lawful renter out faster. The 21 days gives both sides a chance to put forth their rights to being in that property. So those are the issues that I saw with the bill that I wanted to bring to the committee's attention, and which is what puts us in opposition at this point in time.
Good afternoon, Angela Knott from the Washoe County Public Defender's Office, ANGELA, KNOTT. We too are in opposition. And it's just to expand a little bit on what Mr. Pirro stated. My confusion is now on SB 202 as introduced. I was a little confused on the intentionally procures or offers a false or forged rental agreement. I had some concerns maybe we needed some knowingly language in there, but after hearing the presentation, I've decided on two things. One, it's not really fixing the problem. So the problem is the person who actually creates the false document, but they're usually gone, right? So the person who's left is sometimes an innocent renter who's just there saying, no, I'm here lawfully, I have this lease agreement. So what I can see happening is that they get arrested for unlawful occupancy, right? And then now they have to go through and prove that they didn't know that the document was false and that they had a lawful, or they believed they had a lawful reason to be there. So I do have some concerns on how this is going to affect the person who actually had no ill intent. So for those reasons, we are in opposition.
Right, thank you for your testimony. At this time, I don't see anybody else coming forward to give opposition testimony, so we will go to the phones for opposition testimony on SB 202.
Thank you, Chair. The public line is open and working. There are no callers at this time.
All right, then we will move to neutral testimony on SB 202. Come on. Yeah. Come on up.
Good afternoon, Chair and members of the committee. My name is Josh Martinez with Las Vegas Metropolitan Police Department. Just sitting in the back here, just listening to some of the conversation. I know that this is a problem that the legislature is trying to address. There's some other measures that were out there as well that we've had conversation on. So we're happy to help and see if we could craft something. And I know that there might be some questions maybe from the committee that we could assist with.
Indeed, there are, Mr. Martinez. We'll start with Vice Chair Flores.
Thank you, Madam Chair. There's three main hypotheticals that I can think of. Bad actor gets innocent victim, so bad actor A gets innocent victim B, tells him, I own this property, here's the lease, innocent victim comes into the house. Second hypothetical is bad actor goes into the property, they draft up a fake agreement, right? They said so-and-so, and they're pretending to be a victim because, look, I have this fake agreement, I have a right to this house, etc. And then the third hypothetical is, I suppose, what I see online, because one of the things that we did back in 2015, there's these YouTube videos that teach you how to be a squatter, right? And everybody's kind of in on it, and there's people coming in and out of that property, making it very difficult, where bad actor A and bad actor B, they're all in on it. So in either one of those three hypotheticals, can you just help me understand how you think this would make your job a little bit easier?
So obviously, this is Josh Martinez with Metro for the record. This is obviously a fraud situation in all three cases. So in your first case, you're going to have the individual that sees the property that's either A, listed online, and then they contact that person, and then they end up becoming the victim of fraud, right? So we're not here to, usually our constables handle this, but working from my patrol perspective, especially during the downturn of the economy in 2008, and we had the housing crisis, this is not a new concept that's taken place. This is something that I've responded to and many of our officers have responded to in patrol. Obviously, we advise the homeowner and tell them to get in contact with the constable's office, as well as we'll take a police report and we'll document the incident so that way we have a starting grounds for the investigation. In regards to the individual that locates the house and then they become the squatter and they may do title fraud or fake liens on houses, things of that nature that are fraud in nature, we would have to prove that individual knowingly committed the fraud to remain in the house. And that's the difficult part that Senator Ellison's talking about is now I'm trying to get back into my residence that I have legally or trying to get these bad actors out. And there's a long, complicated process. And I've seen the news stories that he alluded to in California where they're almost giving up on their properties, the homeowners, and just allowing them to go to foreclosure or whatever the situation may be because they only have limited resources themselves as a homeowner. So in the third one, it's still going to be the fraud case as well. But in that instance, you're going to have to document it and do a police investigation as we do with all investigations to find where that fraud's at. And could that occur at the state level? Could that occur at the local level? Absolutely. You know, and like I said, this is not a new concept, and I'll just give you kind of what happens. So with stolen cars, you kind of see a little bit of the same thing. Somebody may go steal a car, they may replace VIN numbers, do whatever, and they put it on a corner lot down in southern Nevada and they sell it. And now we stop that car and we find out that car's stolen. We have to impound that car and recover that stolen vehicle. Now that person that's saying, "Hey, I bought this on the corner," they're out money because that car has to be returned to them. This is similar. This is a kind of a similar situation, but this is dealing with the real property of a house. So hopefully that helps.
Madam Chair, if I could do a quick follow-up, and thank you for that. And I absolutely understand that, but all those hypotheticals that you just indicated presently, that's how you address them now. I'm just trying to understand how this is gonna help you in any other way, if at all. I do think from the amendment, section 2, in changing the amount of days, I get that. That's significant. Whether or not the court can do it, that's a different question. So I get that. But I guess I was just trying to understand how this would help you. Because if right now, presently, you find out that bad actor A did not have the authority to rent out that property and has a fake document, then, I mean, they're guilty of fraud at that point. Are you saying that we're also just going to try to go after them for unlawful occupancy as well? Are we just now going to add a second thing we're going to charge them with?
Well, this is Josh Martinez for the record again with Las Vegas Metro. You would be able to charge them, yeah, for the fraud, but they're trying to find a way with this bill would help speed up the process. So by reducing the number of days and reducing it to the 5 days, it's kind of like, the 5-day pay or quit is what we used to tell folks, you know, when they were legally occupying the place and they had to go to the constable's office. And you still have that same remedy where you could go through the constable's office as the property owner, but you do have it's going to be a little bit lengthier process because you have to do the court proceedings, then the constable would have to serve the paper, and then, you know, regular patrol might end up out there as well after the court because people won't leave, and it could be the middle of the night and the constable's office only works certain hours. But this could be another tool in the tool bag if it was to pass, because it would, as you said, move the date, sir.
Thank you.
Senator Hansen.
Thanks, Madam Chair. No, I'm glad you came up. There's a million questions about this, and it's kind of interesting to me to see how you actually can deal with this in the field. And I noticed all the DAs slipped out, which is really kind of convenient at the moment. I'd like to hear how they process this. Senator Noddy actually had a bill earlier where he was going to, I don't know if you're familiar with it, I don't know whatever happened to it. I told him that's a great idea. But it was to allow a property owner, if they're going to be gone for a while, to actually file like a paper with a law enforcement agency saying, I'm going to be gone, this resident's going to be vacant right now. Would that, because what I'm looking to do with the bill potentially, I'm kind of like with Senator Flores. The bill itself right now sounds like parts of it you guys already have the power to do. The 5-day versus 20-day thing sounds like that's a good idea too. Are there other things that we can do? Obviously, it's the very end of the session. There's a mad rush bill if it gets, you know, even if we get a chance to vote on it. Are there conceptual amendments that you could recommend that we could use this as a vehicle to enhance your ability to deal with the bad actors that we're all describing?
Josh Martinez with Metro for the record, again, through the chair to Senator Hansen.
Oh, you can go direct.
All right, thank you. With that bill in particular that you're discussing, the issue is kind of, the issue was getting the letter to a law enforcement agency and then circumventing the processes that we have in place now through the constable's office to remove folks. And I know that looking at the Florida law that was even referenced in this conversation, there were some other punitive things that were there, and that's where the idea came from. But the problem is we have fees in regards to constables and service, but we also have the processes that have to be followed, and that would kind of be giving us the opportunity. Like, we don't want to violate somebody's Fourth Amendment. So if by just giving us a letter, we can't go in there because we get a call and somebody's at the house and then just get them out of the house. So that's the issue that we have with that particular conversation with having that letter to law enforcement is the Fourth Amendment issue that we have to be very cognizant of.
Okay, so that one's out then, so I'm trying to find something good in there. The other question, I wish the DA people were here. When you find obviously bad cases like you described, we know they're bad actors on all parties here. The guy's making a fake lease and the guy maybe even knowingly gets involved in the house. How often do they get prosecuted? I mean, it doesn't sound like there's much fear of going to prison or something for serious fraud things. I know it's an unfair question to ask you because that's something the DA should answer, but I'm kind of wondering how aggressively is this being prosecuted when in fact they find these kind of openly fraudulent situations?
Josh Martinez for the record, Senator Hansen. I could only speak to the police issue, and that's to where I was earlier, is we would get the call or they would come to a station report, and then we would start the investigation process to determine if the fraud was actually committed or if somebody's inhabiting a structure illegally either through fraud documents or they just reside there a little bit longer and they're no longer paying. Then we would start to see if there's the crime that's been committed through the investigation. And I know back, and I've been off the streets for a little while, but 2008, when we were going through this, I know it was a big deal to prosecute folks and deal with those bad actors, because they could live in a house for a long period of time, and then by the time the homeowner gets the house back, there could be thousands and thousands, if not even up to millions of dollars in damage. And now you're trying to recover financial loss that you had but not being able to rent it or inhabit yourself, and then you're trying to fix it.
Well, I got it. No, Jennifer Noble and John Jones disappeared, so I'd like to talk to those guys, but they're not here. But yeah, we're kind of up against the clock, so if there is any ideas, Senator Ellison alluded to the exact situations you're describing where people go in there, squatters, tear the hell out of everything, sell it on the internet or whatever, and then you're the property owner, come home, and you can't even get them evicted in some cases, even though they did such things. All right, I'm talking to the wrong guy. Well, I thank you. I'm trying to salvage something at the last minute here, so thanks, Madam Chair.
Most welcome. All right, any other questions for our witness here or person testifying? Thank you. Thank you so much.
Thank you, Chair and members of the committee, for giving me the opportunity. Josh Martinez again.
And we are still technically in neutral testimony, so we will go to the phones for any neutral testimony.
Thank you, Chair. The public line is open and working. There are no callers at this time.
All right, then that brings us to the conclusion of testimony. I'll invite our sponsor back up to give any closing remarks.
Thank you, ma'am. And Madam Chair, one of the things I was going to say is a lot of people don't realize I can buy every document there is on the internet. I can go downtown right now and buy rental forms. They look so legal. They are legal. But the thing of it is, they just buy them for $1.25. And I've seen these documents that they use in these fake documents to show that they rented this house when they had no right whatsoever. But you can notice when you get there and the locks are changed and the windows and stuff are boarded up or screwed down, the only way you could get in is start breaking windows. But you can buy every contract you want off the internet or from most of the stores here that are legal rental documents. They just don't belong to that house. So anyway, Madam Chair, it's a bad situation, and I'm just trying to hope to get something moving in it to where we can make changes as we go, or get somebody else to pick it up and have changes. But it's sad that people are losing their homes right now or getting extorted to buy them to leave, and then they find out there's tens of thousands or hundreds of thousands of dollars in damage and clothes mess. And one of our senators was one of them. So that's pretty bad. When Stone got hit, he had to buy them to leave, and then the damage to the house was massive. So, but I thank you very much for hearing the bill. Thank you.
Thank you so much, Senator. With that, I will close the hearing on SB 202. I think we've all been kind of looking for a solution to this problem throughout the session, and even though the hour is late, it is not the end. So, I mean, if we can come up with policy answers to the question. I think it's always still worth trying to do that, especially in our biennial sessions when we can't come back for 2 more years. So with that, I will open up a work session on SB 202.
Thank you. I know that Senator Ellison will continue to work on this bill, and I agree with the chair's assessment that these kind of conversations need to keep going on. So with that, I would move to amend and do pass Senate Bill 202.
Second.
All right, we have a motion from Senator Nguyen. We have a second from, I'll take Senator Krasner's second on SB, to amend and do pass SB 202. Any discussion on the motion? Senator Flores.
And I really appreciated Mr. Piro's feedback. I'm sure that Mr. Ellison, Mr. Piro will continue to work as the bill continues to move. I hope we can schedule a bunch of meetings, and Mr. Piro, I will gladly join you in those amazing meetings.
All right. All in favor say aye.
Aye.
Any opposed, nay. Okay, by unanimous vote, the motion carries to amend and do pass SB 202. I will assign the floor statement, of course, to Senator Ellison. And with that, we will move on to our bill hearing on SB 334. I understand our presenter is joining us by Zoom, and I will, maybe also in Las Vegas. You'll tell us about who the presenters are and where they are. Please, go ahead.
Good afternoon, Chair and members of the Senate Judiciary Committee. Yes, I am here in Zoom, and then my colleagues, Dr. Perry and Leslie Turner, are down in Las Vegas. For the record, my name is Quentin Savoy. That's Quentin. Last name is S like Sam, A like Apple, V like Victor, WOIR. I'm going to share my screen as we walk through our presentation of Senate Bill 334 today. Just a little overview of what you can expect in our presentation today. Introductions will give some historical context on this particular issue related to public leasing. We want to illustrate and highlight the relevance of Assembly Joint Resolution 10 from the 2021 and 2023 session, as well as the 2024 ballot measure question 4. During our presentation today, there's a really clear through line there that we should talk about and address. We'll do a bill overview, of course, provide some benefits of SB 334, and then take your questions. We'll start with acknowledgements. Really grateful to Senator Neal for the opportunity to present this bill. Senator Neal has been a champion for this cause the last 2 sessions. This bill intends to establish a minimum wage for incarcerated workers. This legislation was brought forth in 21 and 23, and we're here again to continue this discussion as it is very important. From the outset, we want to say that we did have a good discussion with the Deputy Director of the Nevada Department of Corrections, as well as the Public Information Officer. And we want to be clear that our intention is not to dismantle the existing programs within our incarceration system, but recognize the dignity of all work so that our incarcerated Nevadans can have more firm and established ground when they are re-entering society. So now I'll turn it over to Dr. Tyler Perry of UNLV to give us some historical context on this issue.
Thank you very much. Good afternoon, members of the Senate Committee on Judiciary. Glad to be here with you. My name is Tyler D. Perry, an associate professor of African American and African Diaspora Studies at the University of Nevada, Las Vegas. I was invited here today to provide historical context about the exploitative systems of convict leasing and prison labor, specifically in how such systems as functions of a carceral apparatus in the United States were predicated upon racist and classist concepts of labor exploitation, extending from chattel slavery and other forms of unfree servitude that existed prior to the Civil War. Questions surrounding the racist origins of labor exploitation in American prisons have gained significant traction throughout the 21st century, largely due to the historians, sociologists, legal theorists, and documentarians who've explored the links between the United States' massive boom in its incarceration rates since the 1970s and the racist systems that confined and immobilized Black Americans since the founding of the American Republic. Chattel slavery provided the foundations for the perpetuation of systemic and systematic anti-Black racism, as enslavement in this country and throughout the Americas became a racialized condition that was inherited across generations solely due to a social construction of race that rendered Blackness as inferior to whiteness. And even after race-based chattel slavery ended in 1865, its legacies followed and were most visibly expressed in a multi-layered system that took many forms, including the notorious systems of convict leasing, debt peonage, sharecropping, and prison labor. Though convict leasing was not exclusive to the postbellum South, it undertook an especially brutal form in the late 19th and early 20th centuries in that region. African Americans had gained some momentum during the brief period known as Reconstruction between 1865 to 1877, but after the federal government retreated from the southern states, so-called Redeever governments quickly sought to reestablish white supremacy through violence, domestic terrorism, and by forming an unequal racist legal structure. White Southern legislators sought to immobilize the Black population, keeping many families in states of perpetual debt, or simply arresting many men and women on spurious charges and throwing them into jails or prisons. The basis of the system of convict leasing was one of the most overtly dehumanizing processes, as it allowed private contractors and landowners to, quote, lease convicts from the state, allowing the contractor to profit off of unfree labor. A vast majority of the convict laborers in the South were Black. Many of them formerly enslaved themselves or just one generation removed from the era of slavery. This exploitation of Black people was predicated upon a racist vision of rebuilding the Southern economy through cheap labor, which was directly attached to the white South's rejection that Black people could ever be truly free in the United States. The dehumanization attached to this institution was so intense, it was nicknamed, quote, slavery by another name. And though convict leasing would eventually be eliminated by the 1930s throughout the United States, its counterpart in prison labor was hardly better. Now, Black men, and to a growing degree, women, were considered slaves of the state who produced goods and textiles within the prisons for domestic and international consumption while receiving hardly any compensation for their labor. Historical examples of these harsh conditions abound, including notorious prisons like Parchment Farm in Mississippi or Angola Prison in Louisiana. But the exploitative nature of prison labor and its direct links to anti-Blackness were not confined to this region. As African Americans moved to cities in the North and the West throughout the first 7 decades of the 20th century in an historical event called the Great Migration, they were met with various racist policies in these areas that mirrored aspects of Jim Crow segregation that were mandated throughout the US South. This perpetual curtailing of Black mobility is the key for understanding this issue. Increasingly, throughout the decades following the Civil Rights era, police forces became more heavily armed and militarized, specifically targeting marginalized communities who had fewer resources to combat police harassment and discrimination. By the time of the war on drugs that was amplified under the Reagan administration in the 1980s, African Americans had already experienced what scholar Khalil Gibran Muhammad calls, quote, the condemnation of Blackness, unquote, in which over many decades, white social scientists had equated Blackness with criminality. Consequently, laws were passed on federal and state levels that made the targeting of Black communities, as well as poor people of all backgrounds, rampant throughout America under a supposedly colorblind policy. US incarceration rates skyrocketed during the last days of the 20th century, and due to this reality, this country remains the largest carceral state in the world, despite its proclamations of liberty and freedom. Black people have confronted the worst of these injustices since the founding of the country, and to this day comprise a disproportionate percentage of those who are incarcerated and receiving obscenely low wages for their labor inside. This reality not only allows, but perpetuates and expands the problem of racial inequality within the United States. And so to conclude, the history here produces a few questions I would ask us all to consider. Are we as a society willing to recognize the humanity in everyone? Or do we accept that a person convicted of a crime is only worth their exploited labor and should be defined by such in perpetuity with few pathways for redemption? Nevada made the correct decision in striking the language of slavery and involuntary servitude from its state constitution. It is now up to its leaders to pursue a path toward human dignity, one that is unwilling to further accept labor conditions within our prison system that resemble some of the most heinous eras of American history. Thank you.
Thank you so much, Dr. Perry. We really appreciate that important historical context. And as mentioned in his remarks, I apologize that the image did not populate. It was supposed to be a nice image there that shows you the voting record of legislators from the 2021 session and the 2022 session that unanimously voted in support of Assembly Joint Resolution 10 in both sessions, bipartisan, which I think is really important to illustrate and highlight given the political climate that we're in. We have all decided that this is no longer acceptable in the state of Nevada. So by legislation, we removed language authorizing the use of slavery and involuntary servitude as criminal punishment. Fast forward to last fall, the full citizenry of Nevada voted overwhelmingly in support of question 4 to amend and remove language authorizing slavery and involuntary servitude as a criminal punishment. 60%, 60.6%. So I think it's very important to illustrate that all of the people are in alignment. Everyone is in agreement here. So finding out how we reach a resolution to this issue of convict leasing and our incarcerated Nevadans not being able to earn wages that can set them up to have sustainable living beyond being incarcerated is a very important and relevant question for us to be asking. And we have a really unique opportunity in Nevada to set some really outstanding precedent. The overview of Senate Bill 334 is as follows. Here you see the bill and its phased approach beginning on July 1st. Inmates would be able to receive 20% of the state minimum wage, and it matriculates for 5 years up until 2029, when offenders would be able to receive 100% of the state minimum wage. These are the top lines of the legislation. So it requires, Section 1 requires incarcerated persons to earn progressively increasing percentage of the state minimum wage over a 5-year fixed period. Section 2 requires that said wages be equivalent to or exceed those outlined in Section 1. And then finally, Section 3 requires the legislative auditor to perform an audit of wages paid to offenders each year through 2029. This bill and legislation has the potential to have a great number of benefits for not just those who are directly impacted, but for our entire state. And to go into that more deeply, I'll turn it over to my friend and colleague, Leslie Turner.
Good afternoon. I'm Leslie Turner, LESLIETURNER. I'm the Deputy Director over at FFJC. And I just want to start kind of reiterating what Quentin said earlier, is that the intention of this bill is not to dismantle the current prison industries program, which we all see the value of, and we want that program to be sustainable. Simultaneously, incarcerated people need to be paid an actual wage. And I think the question that we all can weigh in on is 30 cents an hour, is that slave labor? And I think, I don't know, is it? So those are the things that we're here to figure out. And I think more than one thing can be true. We can want to preserve the program, and we can also want to pay people a dignified wage. And the question is, how do we get there? And I think that we're innovative enough, we're smart enough, we're creative enough, collectively, the people in this bill up there in Carson and here, where we can figure that out. So hopefully we'll be able to do that. Some of the benefits to incarcerated people and their families include the ability for people who are working on the inside to be able to support their families, to be able to pay for phone calls, to be able to assist. A lot of people who I know on the inside, their loved ones have passed away during their incarceration. So being able to pay for a funeral or to contribute to community in those ways, not only solidifies and strengthens the family, but it also creates a line of connection that we know contributes to reduced recidivism. And so when we're talking about savings or cost savings in the future, the more people who have those foundations that are set and built with their family and with their community on the outside, they're able to get out, and they're able to reintegrate into society and stay free longer, because they do have a financial foundation to build upon. And then obviously that means more people not going back to prison, means less people ultimately in prison, which brings the cost of incarceration in general down for the state. I think that incarcerated people are also more likely to pay their restitution. Obviously, we want victims of crime to be made whole if that is if financially they're able to be, and so that's something that incarcerated people who are working would be able to do. It also decreases the reliance on social services upon release. Incarcerated people are able to save money, and overall, it contributes to an increased rehabilitation. And then there's the question of question 4, which Quentin was just speaking about, and we don't know how that's going to play out, but I think that that's something that this bill is going to have to consider, and as a body, we're all going to have to consider is when it comes to labor, where does prison labor fall in that discussion, and what is the liability of the state in terms of not practicing slavery? I think I kind of already spoke to the things that are on the slide, but ultimately, I think that we all kind of understand the benefits of being able to work, make money, take care of your family, contribute to your life, and build a foundation so that you can not end up going back to prison. I'll pass it back to you, Quentin.
Good deal. That is the conclusion of our bill presentations. We're happy to entertain any questions. And wondering if Senator Neal is in the room, who can also give some more context for when this bill was presented in prior years, should those questions come up.
Thank you so much. Senator Neal's not here right now. It is that time of session where we're all kind of trying to be in multiple places at the same time. So we do appreciate you presenting in her absence. Any questions from members of the committee? Wow. We have no questions. We have to take testimony. Unless Senator... Okay, so Senator Ellison has a question for legal, so we'll go to him.
I'm looking at some of the letters and stuff in here and the minimum wage, and then what does the prison system pay people for why they're incarcerated?
Senator, that would probably be a better question for the Department of Corrections. I think the amount of wages they pay offenders varies depending on what job it is, but they would know far more than I would.
Well,
Until
this letter popped up, I never thought of it is that way, so I'm just trying to figure an idea about what it was. So thank you, Madam Chair.
And we do have Director Cuenca here from the Department of Corrections, so we'll go ahead and have him answer that question.
Good afternoon. My name is Bill Cuenca, Deputy Director of Industrial Programs with Department of Corrections. If I could go direct, Madam Chair. So there's different stepping stones within the prison industry program. We have traditional wages that we built that does not cross state lines, can vary from $1 to $7 an hour. Now, anything that is made for profit that crosses state lines must be paid the 20th percentile, 20th percentile, or 10th percentile of the prevailing wage for that SOC code. And this is regulated by the Department of Justice, Bureau of Justice. So traditional work, they make $1 to $7 an hour, depending, and we quote to how long it takes to do a bookcase. From the sawyer to the carpenter to the finish shop, and it goes on. We quote the hours for the cost of that because we sell a bookcase for X amount. So we got to stay within there, and we have to generate some revenue at the end. For Certified, which is the Prison Industries Enhancement Certified Program, we do turn in a letter to DETR, Department of Education Training. We send them all the SOC codes, so anything that's for profit that crosses state lines, they give us the study back for that SOC code, for that geographical location. I have welders that make anywhere from $14 to $18 now. I have sewing operation up in Lovelock. And if anything crosses for state lines, they make anywhere from $8 to $12 an hour. So there's a stepping stone, so you come in, you start as a porter if you're an experienced carpenter, you always start at the bottom, you work your way up. So there's a lot of incentive to better yourself and make more wages as you go. I hope that answers your question.
Absolutely. Go ahead, Senator
One of
Allison.
the things they used to have, I don't know if they have it anymore, but they used to have a body shop and paint shop in the prison, and it was still, comparable as any paint shop. I mean, anywhere from $4,000 to $15,000 for any kind of body work, mostly painting. And they had beautiful, beautiful jobs coming out of there. I mean, top line. I don't know if they still do it or not, but that's got to be high dollar because the costs are getting just as much as any paint.
For the record, Bill Quinga, Department of Corrections, we still have that shop down there. We were partners with Shelby. We were partners with Imperial Palace. Shelby were not partnered anymore due to the downturn in the economy in 08 and 10. That I shut the operation down because it wasn't fair for us. Our mission in prison industries is not to displace the private sector. My goal is to get these guys skills to re-enter society successfully. And what I teach them in there, it's not about the dollar. Okay, so I talk to all the offenders in our program. It's about you gaining a skill, changing your mindset, changing your behavior so that you can have marketable skills to re-enter society. I do pair them up with businesses out, such as Lovelock. I have a big 20,000 square foot sewing operation. 30 days prior to the release of that offender, we have a company in Reno, which I can't state, but interviews them with the supervisor. And we have many of them come out and go right to that factory locally with benefits, health benefits, and whatever benefits they have, and a great wage. But they learn that skill. So a lot of these offenders come in, they have no skills. It's their first job. But I teach them it's not about the dollar, it's about your mindset and being a great citizen, and that I can go in there and make $80,000 and send them home with $80,000, and I testify to another committee. But if you don't address your issue, whether it's substance abuse, alcohol, or whatever, you're gonna come out, you're gonna come right back. You think they're gonna buy a house with that money. I've seen it. I've been in the department for 30 years, and I'm very passionate about this program.
I can tell you it was one of the best ones I ever saw, and these guys were fantastic. And these guys come out and got jobs overnight. So I just hope it's still going and hoping it expands. Thank you very much.
Next, we're going to go to Senator Nguyen, and then I'll jump back to Senator Hansen.
Oh, always the problem of having someone on finance that's also on here. So I appreciate, and I appreciate you highlighting the positive success stories of this. Obviously, I support the need for legislation like this because even when you have someone that is making, say, $18 an hour, and they're gaining those skills that I think are invaluable, especially for to reduce recidivism, to have more satisfaction, and to reduce violence, and even mental health issues while they are incarcerated. Nearly about half of that salary goes back to the prison. Isn't that correct?
For the record, Bill Quagga, Department of Corrections. There is a stat the last committee talked to about Marcy's Law, and I could not begin to tell you who's in first, but there's 24.5% that goes to, I believe, room and board. And please don't quote me. I think it's if you make over minimum wage, then you start paying.
Yeah, and I don't take offense to money that is going towards restitution pursuant to Marcy's Law, to make sure that these victims become whole and have that kind of money. But as far as the people that are working, they are responsible for their room and board, as opposed to someone who sits there and does nothing while in the prison system. They don't have to pay for room and board. Is that correct?
For the record, Bill Quinga, I believe so. I cannot confirm that, but I believe that is correct.
Again, I appreciate the fact that we have these robust programs that are in the private sector that are probably paying a lot more and giving actual more skills. But we do have other jobs that are institutionalized that are making sense on the hour. They are not making minimum wage. Is that correct?
For the record, Bill Quagga, yes. So the department has their own side. NDF has their own side. I'm solely responsible for prison industries, for industrial programs, where we can enter agreements and partner up with the community and manufacturers to try to develop a workforce for the outside.
And like I said, I appreciate the programs. I appreciate the work that you put into it. I know that your passion comes through, and I do think they are good. But I think if I didn't point that out, because sometimes people might hear this, they might hear like the positive success stories that you're talking about and not realize that there are like hundreds of individuals that are incarcerated that are working for cents on the dollar within some of those institutionalized jobs. So thank you, and thank you, Vice Chair.
Senator Hansen, please.
Thanks. Several questions. What's the current prison population?
Current prison population, last check this morning, was 10,515, approximately.
10,505. Okay, now, we're talking involuntary servitude. I force the taxpayers of Nevada, basically, to pay for the entire prison system, for all the law enforcement people in our communities, for the public defenders, the district attorneys. It is in the hundreds of millions of dollars that we force people to pay in taxes to basically take care of 10,500 prisoners, which costs us $35,000 each. So when we're looking at involuntary servitude, the people that are in the prison systems are not there because they're nice guys and, you know, everybody's just going back to 1930s Georgia or something. These people have committed serious crimes. Now, I am 100% supportive of the prison industry system. You guys used to have your restitution program, which was excellent too. I don't want anybody going back into the prison, but the presentation today gave me the impression that we are exploiting people that did nothing wrong, and we're putting them into the prison system, and it's going back to slavery days. I think that's baloney. If anybody's being forced to pay something against their will, it's the taxpayers who are paying for this entire system to try to prevent crime in our society. So, you know, as I hear this program, I'm all for getting people who have done terrible things when they come out to not go back. Okay, I want them to learn skills. I've worked with a bunch of the felons that had through the restitution program in my plumbing company. But the argument that's being presented today is like we are exploiting innocent people's labor and forcing them to work against their will. Can you right now in your prison system force anybody to work?
For the record, Bill Quenga, Department of Corrections, no, sir. Involuntary servitude, no one is forced to work in the Department of Corrections, whether it's prison industries or Department of Corrections such as porters, law clerks, or working in the culinary.
Okay, very good. Well, that's kind of what I'm getting at. I mean, look, I want prisoners to be paid when they can. I want them to be able to use the monies in the stores you have and pay for their phones and all that. We did address those issues previously where, because frankly, we don't give you guys enough money, we were having you guys charge prisoners too much for phone calls and things like that to help compensate for, frankly, what the legislature failed to do, which is provide the adequate dollars for the prison system. So, but on the other hand, this has a $100 million plus fiscal note on it. So it's like, I'm not going to push the taxpayers any more than we already have to finance the entire criminal justice system, from the cops on the street, right through the DAs, public defenders, and you in the prison system, and now add an additional tax burden to help people out who shouldn't be in there in the first place if they had obeyed the law. We seem to miss that part in this discussion. If you obey the law, you don't end up in prison. And when you break serious laws, you end up in places like that, and then I'm forced to pay $35,000 a year to keep you there. And hopefully after you go through that whole process and get back out, you don't go back. But I mean, we're talking like everybody in there's some innocent person and you guys are exploiting their labor and da-da-da-da. Don't buy the argument. Do want to try to help? But the whole tone of this discussion has been remarkably one-sided. So just want the committee to know and the people testifying there's more than one way of looking at this. And I don't see Nevada being, 1920s Georgia or 1867 going back to Reconstruction when the former slave masters were exploiting the labor of the prison populations at that time. Sorry, don't buy that argument anymore in Nevada. I want to look out for the taxpayers, and I think they're already paying plenty for people that have broken the law. Don't break the law, and then you don't have to worry about going back to prison or in prison in the first place. Thank you, Madam Chair.
Madam Chair, can I make it?
Please, go ahead.
Senator Hansen, so one thing I want to point out is the prison industry program is a self-supporting program. We get no general fund. What we make is what we earn, and we keep the program revolving. It pays my salary and up to 19 of our staff. So for us to increase it and all that, it would dissolve the program. I can guarantee you in 3 years, you would not, and close your eyes and imagine Department of Corrections without a prison industry program.
Well, thank you for that. And I just, I'm 100% supporter of the prison industries program. I've toured the prisons. I think the whole concept is great. I want people that are incarcerated, who, as you noted, often lack even the most basic skills. We've helped pay for computers and done all sorts of things to try to help so that we reduce that recidivism rate. But there's kind of a limit there. And I don't like the idea that we in Nevada are putting people in prisons to exploit their labor rather than insist that they pay for the crimes that they have committed. The other thing we didn't address at all, and that is, if they are in fact getting paid wages, should they pay the taxpayers back for the prosecution costs, for the incarceration costs in general, not just for the labor for whatever they build in the prison industry systems? And should we in fact make it so we do have some sort of mandatory labor program for able-bodied people in there, and then pay them the wages, but then they get to pay back to the taxpayers all of the monies that we have are forced to pay through taxation for their bad behaviors. So, thank you, Madam Chair.
All right. I think we still have a couple questions, if you don't mind. Senator Orenshaw.
Thank you very much, Chair, and thank you, Deputy Director, for being here. I guess my question, kind of following up with Senator Hansen, is for someone at an NDOC facility who decides to participate in a prison labor program, can you just kind of describe how someone is selected? Is that something they volunteer for, or is it something that they're chosen to be, are asked to participate in it? And what are the benefits to a prisoner who participates in one of the NDOC work programs?
For the record, Bill Coingo, Department of Corrections. So in the prison industries program, we try to mimic the private sector as much as we can. In all our shops and operations, I have the supervisors post through the chief caseworker, and the associate warden programs. We post a job announcement in the units that are general population. Of course, we have a level system. So what they do is they get the announcement, they get with their caseworker to see if they're eligible. So then the caseworker would determine whether they are. They would submit an application. They would submit it to the supervisor for that industry program. He would review it, then schedule an interview. Once they're interviewed, we'll send a list up of the candidates they'll send a list of who was selected. That goes to a full classification committee, which could be the warden or associate warden, the caseworker, and a correctional officer or sergeant or lieutenant. They must be reviewed to ensure, was there any staff assaults, was there any previous attempted escapes, and their behavior as far as violating any rules within the facility. That committee makes a decision whether they're eligible to get behind the fence, we call it, to work in prison industries. So when they come in, there's a pay range. In all my industry programs, we try to mimic, like I said, mimic the private sector. We have a carpenter 1, carpenter 2, and 3, welder 1, 2, 3. We have a sawyer, and they start out at a level and they get evaluated, and they move on. But we like to backfill to where the most experience has somebody shadowing behind them, because we don't know when these guys are going to go home. They could leave. Laws change, and I tell them all the time. But we got to keep that learning curve up, because we operate as a business. We don't just get funds, just come in and we just disperse them and keep buying and going on. But they're selected. The benefits, they get preferred housing. Usually all the workers are one unit. They get to go feed first in the morning, and then they come to work. But they have opportunities. They can buy their own boots. They save their money, can't buy boots. Our welding program partnered with a college program. They provide testing equipment. I got a instructor, a professor working in there, but there's other programming that we offer within prison industries. I know we have a reentry program. We're still building that up. But in the years I've been in prison industries, I was a firm believer, we got to give these guys something to do. Idle hands are a threat. And I want these guys to be successful, and I have many of them out there that I could share success stories one of these days, or if you guys are interested, that these guys love the program, they volunteer for the program, nobody's forced. And we demand work ethic, and we watch them to make sure that they're performing, and we try to mentor and guide them to do the right thing.
Thank you very much, Deputy Director. Chair, would you indulge me with 2 brief follow-ups?
Sure.
Thank you. You mentioned that someone who's able to participate in one of the prison work programs gets preferred housing. Does that mean they're no longer general population, or are they still
For the record, Bill Coinga, Department of Corrections. No, it's still general population, but we try to keep all the workers, like colony workers. So colony workers work different hours. So we try to keep them by education, by workers, and culinary. So they have different schedules of movement. So we don't want people moving around. And that's up to the warden and the department to decide which units as far as behavior. And generally, the workers unit, we don't have any issues.
Thank you very much. And then last question, Chair, with your indulgence. Deputy Director, you mentioned success on the outside. Do you have any data or any about folks who were in prison work programs and their recidivism rates compared to folks who didn't participate? If you do, I'd sure appreciate that if you could share it with me and maybe the committee. If you have that info or if you know it offhand, I'd sure be interested.
For the record, Bill Quegget, and I do not, and we're trying to track that. I have my peers with the National Correctional Industries Association are working on that. Also working with our deputy director from our programs, reentry program, with recidivists. And that is going to be amazing. We get that program in to track all these offenders, and we can track them from the horse program, from the compost, or which industry and which facility they came in to track them for recidivism. But I can tell you, with my peers, those who work in the industry program, the recidivism is really low. I couldn't tell you the exact number. I would not want to quote that.
Okay, thank you very much, Deputy Director. Thank you, Chair.
All right, thank you.
May I say something?
Yes, go ahead.
Oh, sorry, Tyler D. Perry for the record. I just wanted to address some of the concerns raised a little bit earlier, really briefly. And I want to just emphasize this is not a abolition bill. This is not suggesting that people who are not convicted of a crime should not repay their debt to society. It's simply saying that the functions of the prison system, and particularly the exploitation of labor there, is troubling to most people who would have some understanding as to what compensation for labor means. We've had a very robust labor rights movement in this country, and particularly in Nevada as well, in recent history, that really linked a person's human dignity and humanity to honest work for honest pay. And the issue, I think, that we're trying to address is that just because a person's convicted of a crime, I cannot accept that they lose that element of their humanity and dignity because the cost seems too high. As noted in Leslie Turner's portion of this presentation, if a man or a woman is sent to a prison and they're able to earn at least a fair wage, or at least a wage that would match the state minimum wage, that would actually allow them to provide for the family that once depended upon them before they were incarcerated. And so this could also lead to improved rates of recidivism. And so in the long run, I think most would argue that a fair wage for labor provides human dignity. It provides a person some type of optimism once they're released, that they can actually really re-enter society and feel of value to the community that they would re-enter. Thank you.
And I wanted to also just add Leslie Turner for the record, Leslie Turner, Turner, that prison industries is just one piece of this conversation, and it seems to be very focused on prison industries. And as Senator Nguyen pointed out, there are hundreds of people who are not in prison industries who work on the tier, that work in the law library, work in culinary, deliver the trays to the other incarcerated people who, again, this is labor that is not paid. Where a person makes it to prison, they're serving their time. They're repaying their debts to society. That is a separate thing from labor. This is what we're talking about here. And ultimately, the voters have already spoken on this. So I think that that is a huge factor that has to be considered. And there, again, back to the people who are not in prison industries, which Director Coinga, maybe you can share exactly those numbers, how many incarcerated people of the 10,000 are actually in prison industries. But the hundreds of people who are just working and not getting paid at all, that would be akin to it's unpaid labor. So that has to be addressed. And I think that the other thing I wanted to point out is the fact that it said that it's voluntary. Well, is it? Is it? Because And again, this is why it's important to understand the inner workings of prison and to go in there and actually talk to incarcerated people, so that you can understand the way things really work on the inside. But if you refuse to have a job, you'll get moved to a unit, for instance, on high desert. You'll get moved to a unit where um, you're on lockdown most of the time. So again, yeah, you're not getting forced to necessarily, but technically there are incentives there to work or not to work. So I think that ultimately this is a question about labor. And that's really, and giving the historical context is important. It's always important to know from where we came from, how we got here. And I think that was the intention of our presentation.
Thank you. I appreciate that. And I also wanted to address, my colleagues' comments, who I have tremendous respect for. I did not hear this presentation the same way. I did not think that anybody was suggesting that innocent people were being enslaved, but that the presentation provided very important historical context, because our criminal justice system, our legal system, our prison system is built on a very horrifying history of Reconstruction, and that has systemically oppressed people of color. And thankfully we have evolved, but that doesn't mean that we don't still have vestiges of that same underlying system that contribute to the problems that we face today in making our criminal legal system more fair. And so I think that the presentation did a good job of utilizing the past to inform the present without suggesting that we haven't changed or evolved at all. And I think that we all agree that people who are incarcerated are paying their debt to society, and we can have reasonable disagreements about what the inner workings of that look like and what kinds of benefits and privileges people are entitled to when they're incarcerated, as well as what rights they still maintain when they're incarcerated. So I appreciate all of you presenting. I appreciate you, Director Koenga, coming up here to answer questions for us. At this time, seeing no further questions, we will proceed to testimony on SB 334. We will begin with, right? Yes, okay. We will begin with in-person testimony in support of SB 334 here in Carson City, as well as in Las Vegas. We'll start in Carson City, though.
Sorry, just wanted to make sure it was on. Harrison Epstein, for the record, Harrison Epstein. I'm a legal extern for the Clark County Public Defender's Office. First off, thank you, Chair, thank you, members of the committee. I want to thank the bill sponsor and the presenters for all being here today. The minimum wage in Nevada at this time is $12 per hour. Some incarcerated people in this state are being paid as low as 60 cents per hour to be welders, automotive painters, ranch hands, and carpenters, according to the Silver State Industries pay document. A non-incarcerated welder in this state would likely earn over $20 per hour. A person working these same jobs just outside of a prison or jail facility would be paid far more for the same work. If this bill becomes law, an incarcerated worker in these jobs would, this year, have their pay increase to $2.40 per hour. Increasing the pay for incarcerated workers would trickle down to help everyone involved in the system. Receiving higher wages means incarcerated people would actually be able to make restitution payments, helping victims be made whole. It would give incarcerated people better access to food, hygiene items, and communication with their families. It would lessen the financial impacts for these families seeking to help their loved ones afford the bare minimum while they're incarcerated. It would potentially allow incarcerated people to save money, so when they're eventually released from prison or jail, they have an opportunity to restart their lives with a safety net. It would mean a smoother reintegration and, ideally, reduce recidivism by treating incarcerated people with dignity and respect. Thank you.
My name is Aisha Goins. I am the first vice president of the NAACP 1111, and I support this bill specifically for dignity and respect, and I ditto the comments before me. Thank you.
Thank you, Chair and committee members. My name is Nick Shepak, N-I-C-K-S-H-E-P-A-C-K. I'm the Nevada State Director of the Fines and Fees Justice Center. As our Deputy Director helped present this bill, it is clear that we support it. But this is something I've studied for many years, and there's a few things that we need to think about. Regardless of whether or not we can afford this now, it is an important conversation, right? This is a policy committee. If it makes it to a budget committee, that conversation can be had there. But the question is, when do we pay? So currently, in our system, we do have, there's somewhat a sense of coercion to work, as if you do not work, your time in prison is significantly worse. Whether you're making 30 cents an hour or you get one of these great jobs where you're making $17 an hour, there's a huge incentive to do these jobs, almost a punishment if you have the opportunity and do not take it. But what we end up doing is millions and millions of dollars from our communities flow into the prisons to pay for things like food and phone calls. Things that don't get paid include restitution, because the individuals who are incarcerated never make enough money to pay that restitution. We ensure that everybody is set up with social services, Medicaid, upon release, that all taxpayers' money, because people have no money when they come out. We're deferring a cost. We're not actually saving money through the current process. And so the question we have to ask ourselves eventually, and hopefully we can get there one day, is where do we want to spend this money? And when people are providing labor for the state, producing items that we are selling, or allowing the prison system to run, do we believe in paying them fairly? And if we do, some sort of bill that gets us towards a minimum wage is a way to do that. We will save an insane amount of money on the back end, and the money that will go into items that are taxed and back into our communities, into rent and into grocery stores, instead of from families into the prisons, will be a huge net win for the economy and for the state. So it's a much more complex issue. We don't have time right now to get all the way into it, but it isn't simply just moving a bunch of money in and saying we're giving it to them. There is a real cost benefit to the state when you ensure that incarcerated people are able to make some sort of a wage that is meaningful. Thank you.
Good afternoon. My name is Tia Smith, T-I-A-S-M-I-T-H. I'm a policy attorney with ACLU of Nevada. We support this bill for the reasons that have previously been mentioned, and we urge the committee to support the bill as well. Thank you.
Thank you. I don't see anybody else coming forward to give support testimony in person, so we'll go to the phones, please, for support testimony on SB 334.
Thank you, Chair. If you would like to testify in support of Senate Bill 334, please press *9 now to take your place in the queue.
Good afternoon, Chair and the committee. My name is Ashley Dodson. That is ASHLEY-DODSON for the record, of Anchor Perspective, a community organizer and policy analyst calling in support of SB 334. I would like to thank our presenters and my colleagues, Quentin Savoy and Leslie Turner, on behalf of making sure that those who may have previously committed offenses are still being treated with dignity and respect, and also knowing that no matter what the situation was, that people still have the opportunity to provide for their loved ones. So I would urge you to please support this bill. Thank you.
Good afternoon. My name is Denise Bolaños Heredia, Bolanos Heredia, and I'm the Associate Director of Return Strong, and we're in strong support of SB 334. Let me begin by stating what should be obvious. The punishment for a crime is the loss of freedom, period. Not the loss of dignity, not forced labor for pennies, not the many other injustices that often come with incarceration. It was said earlier that people should just obey the law if they don't want to go to prison. That ignores the critical truth that thousands of people across the country have been wrongfully convicted and later exonerated. Innocent people are in prison, and even for those who are guilty, their humanity doesn't disappear at sentencing. No one deserves to be exploited. Incarcerated people perform real, valuable labor. They support public agencies, private companies, and even risk their lives fighting wildfires, yet they're paid next to nothing. That is exploitation. Paying fair wages isn't just right, it's smart. It helps people support their families, pay restitution, and prepare for release. Economic stability reduces recidivism and makes communities safer. And at the end of the day, this bill is about recognizing that people inside are still people. They have worth, they have rights, and they deserve to be treated with dignity. Please pass SB 334. Thank you.
If you've recently joined us and would like to testify in support of Senate Bill 334, please press *9 now to take your place in the queue. Chair, the public line is open and working. There are no further callers wishing to testify in support at this time.
Thank you. We'll move to testimony in opposition, starting in person here in Carson City. Come on up.
My name is Shane Johnson. That's ShaneJohnson. I worked in prison industries for 15 years. I was in prison. I went in when I was 16, had no marketable skills, no direction in general. And the reason I'm here is to speak in opposition, mainly due to the fact that there's no distinction between prison industries and regular prison labor. Because if this gets clumped up as one thing, prison industries being a self-funded program, being insolvent is a terrifying thought. That place gave me the opportunity to learn to weld, to learn to fabricate, and I was able to get out and land. I'm a general manager now at a structural steel contractor, and the work I did in there directly affected the rest of my life out here. And if that opportunity isn't there for people who are on the inside now, the thought of that is terrifying, because there is no other place inside the prison to gain an actual marketable skill that you'd be able to take into the world. So that is my opposition. I did want to, Senator Wynn's not here, but I did want to kind of touch on the issue of room and board. There is money that is deducted from your paycheck while you're in there for room and board. It equates to about 34.5%, which is what goes back into the general fund. So it's not quite as much as we would like to be able to put back into the taxpayers to compensate for our time in there, but it is something that goes back into it. And also, there was a question regarding restitution. Restitution, when you work in prison, is taken out automatically. So regardless, if you're making money, you're paying restitution. So those things happen just off the top. So anyway, that is my argument against this bill. I don't think that it's a bad idea, and I don't think that there's anything wrong with dignity and putting all of those things back into the people's hands. But I feel like there should be a distinction and a carve-out made between the generalization of labor in prison and prison industries, because those are two totally separate entities and should be treated as such. Thank you.
For the record, my name is Bill Coinga, Chair Scheibel, members of the committee. Thank you for having me here today. The role of prison industries goes beyond just financial compensation. It's about purpose and skill development while incarcerated in preparation for successful reintegration into society. Prison industries is a vehicle for so many offenders to find purpose while incarcerated, prepare for successful reentry, and to secure meaningful employment on the outside. It is misleading to group together all prison industry programs nationwide. Silver State Industries in Nevada operates much differently than programs in other states. The federal system of private prisons, the pay rate in Nevada is far above the national average and is 100% voluntary. According to a 2017 survey published by the Prison Policy Initiative, Nevada prison industries pay the highest wages nationally. No state pays either federal or the state minimum wage. During my 30-year career in corrections, most of which I spent in prison industries, I've always treated the workers with fairness and respect. I believe strongly that workers should be paid a wage that acknowledges the dignity of their labor and reinforces the idea that all work is valuable. It can help improve their sense of self-worth and promote a healthier mindset, contributing to a better rehabilitation. But a livable wage inside prison is different than on the outside. Offenders who have their necessities paid by the taxpayer have fewer financial obligations. Workers come in at a starting wage and are offered opportunities to promote. For many of them, this is their first job ever. They learn the soft skills of showing up, working collaboratively, and taking pride in a job well done. We observe their work ethic and skill, and over time, they work their way up in rank and pay. Focusing on wages is important for addressing issues of fairness and exploitation, but it's equally crucial to consider how work programs can contribute to rehabilitation, skill building, personal growth, and reduce recidivism. Prison industries is a powerful tool for reforming the justice system and providing incarcerated individuals with the tools they need to change their lives. I've seen firsthand the difference this program has made in the lives of workers during the incarceration and once they are released. I keep in touch with many of them once they are released, and I'm pleased to say that most of them are in meaningful, high-paying careers and have built successful lives and families. Thank you.
It looks like we have one more question, if you don't mind, from Senator Ellison.
Thank you. And the gentleman that spoke a minute ago, he talked about, making restitution. We've had several people go to prison for breaking into buildings. My daughter's house, they beat her dog to death. They stole her husband's brand new motorcycle. They stole guns, being ex-felon. Stole guns, tapes, tape recorder, everything they could take, they stole and destroyed in this house. And they were supposed to pay restitution. And she kept waiting, talking to the parole people, and they said, no, you don't want to work because you don't have to pay it back. So there's no way to get the money that was owed and the damage to this. And this motorcycle, I bet you didn't have 50 miles on it. And they chopped it somewhere. But, I mean, it goes to show you. And I had people steal cash machine or change machines out of our laundromat stuff. They were forced to pay restitution. They've never paid a dime. And it just goes on and on and on. And when they robbed the laundromat, they got about $40,000. Not one penny was ever paid back. So these guys that get there that don't want to work, they won't work. Is that correct?
For the record, Bill Quang, Department of Corrections, as I mentioned earlier, everything's voluntary. I have seen through my career that a lot of the offenders that are in there, it's just changed from when I started my career, and a lot of them do not want to work. And it saddens me because they just want to sit on the rack, and I try to get the supervisors, caseworkers, and push to, hey, let's get these guys in. If they qualify, let's teach them some, because I've seen a lot through my career where they come in and they didn't want to work, but then all of a sudden they take pride. Gentlemen that just testified and others that came in, it's like, wow, this is the best thing. Makes their time go by faster, they're productive, and it doesn't mess with their head being, incarcerated in there. They're almost living like a half of freedom for them because they have a purpose to get up in the morning, rinse, repeat, recycle, go. So we have operations where they do that, where they just filling an application, just going to work, gives them self-confidence and self-worth, even though they're not making as much money, but they have that because they've never done that. They're up partying and all that stuff, so now they have a purpose and builds their confidence that, hey, I can go to work, I can get up, I can do something.
Follow up, ma'am? Sure. And I hired 2 individuals that come out of the prison system that were workforce. They were great. I mean, they showed up on time, they didn't drink, they ended up being really, really good employees. Finally, they, when they got everything cleared and got some time under their belt, and the mines picked them up. So that's pretty good. I mean, they got a trade that they could take on and become good, honest citizens. So I think the workforce is good. Money is made in the prison system, but thing of it is that they come out with a, $50,000 career, these guys make $100,000 a year now, but I mean, they come out of prison with, if they went to get that out of the college, they'd have paid $50,000 or more. So that's what I look at as benefits. So thank you.
Right. Thank you for your testimony. I don't see anybody else coming. Oh, we do have one more person coming forward to give opposition testimony here in Carson City. Go ahead.
Larry Plumley, Larry Plumlee. I served 34 years in the Department of Corrections. I was in support of this bill until I've listened to it. And in relation to prison industries, I've done the math when I was a clerk there. I left in August. And a piece rate could probably somehow work out, but you're talking about all inmates within the Department of Corrections. They're paid through the Inmate Welfare Fund, which isn't, it's a fund that the inmates pay through to get products of canteen or whatever. So now what you're saying is then the state is going to subsidize it? That's one of the reasons I'm opposed to this bill. I also posted a letter listing all the other reasons. I don't believe the motto should be commit a crime, get minimum wage. It just doesn't seem realistic. And now the more I think about it, as somebody that was there for 34 years, I don't think I would have supported it when I was in prison, let alone out here on the street. Thank you very much.
Okay, I think that concludes opposition testimony here in Carson City. I don't see anybody coming forward to give opposition testimony in Las Vegas, so we will go to the phones, please, for opposition testimony on SB 334.
Thank you, Chair. If you would like to testify in opposition to Senate Bill 334, please press *9 now to take your place in the queue.
Good afternoon, Chair Scheibel and committee members. My name is Jim DeGraffenreid, JimDeGraffenreid. I'm Nevada's Republican National Committee man here today in opposition to SB 334. We first object to the twisting of the legislative intent of AJR 10, which correctly affirmed that slavery and involuntary servitude are not constitutional punishments, and we know that they don't exist in Nevada. This bill has zero nexus to AJR 10. Nevada inmates are not sent to forced labor camps. They are rather punished by temporary loss of freedom. While incarcerated, they have the voluntary option to better themselves and learn skills for their future, as testified to by Deputy Director Cuenga earlier. Typical minimum wage arguments don't apply. We've heard over and over that minimum wage is needed to provide workers with a basic standard of living. While that is itself a flawed argument, minimum wage is typically justified by showing the expenses of housing, food, childcare, transportation, other necessary costs of living. I have a fact sheet from the Economic Policy Institute from January 26 of 21 titled Why the U.S. Needs a $15 Minimum Wage. It states today in all areas across the United States, a single adult without children needs at least $31,200 to achieve a modest but adequate standard of living. However, this logic is irrelevant in a prison setting. Inmates don't pay for housing, food, healthcare, transportation, or indeed most of the other necessities of life, at least not to the full extent of these expenses, as Senator Hansen pointed out. If inmates earn minimum wage, then they should have deducted from that wage the full expense the taxpayers are paying for. We should also deduct for income taxes, Social Security, Medicare, etc., as these are also figured into the necessities of life within minimum wage. And I suspect that the net would be less than the current highest in the nation wage scales as specified by Deputy Director Cuenga. We oppose excessive taxation, particularly when the taxes are used to promote irrational and unfair public policy, and we urge you to reject SB 334. Thank you.
For the record, my name is John Nicholas, Nicholas. I was incarcerated for 28 and a half years, and I worked for prison industries for 20 of those 28 and a half years. and I'm in opposition of this bill. I was an admin clerk, and I've seen what PI actually does with their accounting, and I'm concerned that if you were to force minimum wage on the prison industry, that it would kill the program because the program would not be sustainable due to the fact that there are other factors that are being involved with overheads, room and board, and the victim's crime fund. I started out as a purchasing clerk and moved my way up and learned accounting and was taught by the Department of Corrections accounting. And with that knowledge, I've turned my life around since I've been out, and I am now a senior support specialist for Intuit, and I clearly make over $100,000 a year now. I'm a productive citizen in the state of Nevada, and I just don't want to see this program killed, because the fact of the matter is that teaching somebody a new trade besides robbery 101 or murder 102 is beneficial to all taxpayers, because when we do get out, then we are part of the solution and not part of the problem. With the wages that I made, even though it wasn't at the inflated rate of 12 something an hour, I was able to pay for my own college and walk out of there with 2 associate's degrees, and was able to turn my life around with this program. So I am strongly opposing this bill, because I do not want to see that this bill kills the program and takes away the benefits that are actually being achieved by participating in this program. Thank you.
Chair, the public line is open and working. However, there are no further callers wishing to testify in opposition at this time.
All right, thank you. We will move then to testimony in neutral on SB 334. Anybody wishing to give neutral testimony is invited forward now, but I don't see anybody coming to the table in Carson City or Las Vegas. So we will go to the phones, please, for neutral testimony on SB 334.
If you would like to testify in neutral for Senate Bill 334, please press *9 now to take your place in the queue. Chair, the public line is open and working. There are no callers at this time.
All right, then that brings us to the conclusion of testimony. I will hand it back over to our presenters. Senator Neal was here briefly and has returned to the other committee that she is chairing right now. So if the presenters have any closing remarks, please go ahead.
Thank you so much, Chair Scheibel. I really deeply appreciate such robust and public discourse about such an important issue happening in our state today. I want to just clarify some of the misnomers that got characterized throughout the hearing. This isn't a bill about race. We gave the context of slavery and involuntary servitude so that we do have a sense of from whence we came. I'm old enough to realize now that life just happens in cycles. It just looks a little bit different later on down the line. So I want us to just all be aware of that from which we've come, in order to best understand how we can devise solutions that are going to be equitable and fair and sustain this program and continue to have some of the success stories that we heard about today. Also want to reemphasize that my colleagues and I are in support of the prison industry's program. Like, we totally understand the skills that it's providing. We totally understand the success stories. However, what's missing for us in this is the data. The data that outlines how many welders are there of that 10,000 number that Deputy Director King referenced, right? What we are trying to get at is the dignity of labor. And because you make a mistake in your life once or twice, or even 3 times, should not take away your ability to have dignity in the work that you can do. It is in that work that you can be rehabilitated. It is in that work that you can be a value add to your community. It is in that work that you can get reacclimated to society. So this idea that you mess up one time and we just throw the whole person away, we just wholly reject that. And it's not a good way to govern a state. So we really appreciate the conversation. Thank you so much to Chair Scheibel and all of the committee members, and we look forward and hope for your support.
Thank you so much. At this time, I will close the hearing on SB 334. We are going to take a brief recess to recess, and we'll be back in a few minutes. All right, we are back from our brief recess. Thank you for sticking with us. At this time, I will open up a work session on SB 334. We've had a conversation amongst stakeholders, including people who are here on the committee. We've talked to the sponsor of the bill, and I would accept at this time a motion to amend and do pass. The amendment that we're looking at adopting would actually replace the current text of the bill. The amendment would require the Department of Corrections to provide a report to the interim finance committee during the interim, finance during sessions, and the legislative commission that outlines how many people who are incarcerated are employed in various industries, how much they are paid, and how many people get jobs in those same industries when they leave the Department of Corrections. And so with that,
Madam Chair, one quick comment on that.
absolutely.
Could we also include the number of prisoners that basically refuse to participate in those programs?
Absolutely. You could include the number of eligible people who are incarcerated, the number of people incarcerated who actually have these jobs, et cetera. Senator Nguyen.
I'd so move to amend and do pass as you just recommended and laid out with the amendment that Senator Hansen mentioned.
All right, we have a motion from Senator Nguyen. We have a second from Senator Ellison. Any discussion on the motion? All right. Would you consider modifying your motion to also include any deductions from the pay?
I would like to rescind my motion, and hopefully Senator Ellison will rescind his second.
Looks like it.
Rescinding the second, and I would make an additional motion to amend, and do pass as laid out by our chair.
All right, we have a new motion from Senator Nguyen. We have a new second from Senator Ellison. Any discussion on this motion? Not seeing any. All in favor say aye. Aye. Any opposed, nay. All right, the motion unanimously carries to amend and do pass. I will assign the floor statement to Senator Neal. And with that, we are going to open up one more work session on everybody's favorite bill, SB 20. You might have forgotten that it even exists, but it does. And it also doesn't, because we have an amendment in front of us that removes sections 1, 3, and 5 from the bill. Are there any questions on the bill or the amendments? I don't see any questions, so I'd accept a motion to amend and do pass.
I'd so move to amend and do pass.
Second.
All right, we have a motion from Senator Nguyen. We have a second from Senator Flores. Any discussion on the motion?
To be honest, I don't know what the heck I'm voting on.
Do you want to turn on your mic? Do you want to turn on your mic? Do you want to turn on your mic and add those comments to the record?
I need some practice. Piero couldn't remember to say his name. I can't remember to turn on my mic. We're all getting old. I just say I'm going to vote no, because I have no idea what I'm voting on, honestly. So, but I do reserve my right to change. Thank you.
Understood. And with that, all in favor say aye. Aye. Any opposed, nay? Nay. All right, the sole nay is Senator Hansen. The motion does carry to amend and do pass SB 20. And the floor statement will go to a volunteer named Senator Nguyen. Okay, with that, that concludes our work sessions and our hearings for Senate Judiciary Committee for the rest of this week. We are canceled tomorrow. We will resume committee at some later date. Next week, we anticipate being on the floor a lot and not being in committee much, if at all. So stay tuned, keep posted. Thank you as always to everybody who has. Oh my gosh,
You're getting old too.
I am. You can go. Is there any public comment here in person in Carson City or Las Vegas? Is there any public comment on the phones?
Thank you, Chair. The public line is open and working. There are no callers at this time.
All right. Public comments now closed. Meeting's now over. Thank you, thank you, thank you to our staff. They are the absolute best. And before I mess it up again, we are now adjourned.